Hi, I'm Janice Pettit, and I'm here today speaking with Jonathan Melton. Jonathan is an attorney with the Raleigh divorce firm of Gailor, Jenkins, Davis, Taylor, and Gibbs. But he's also a board-certified family law specialist. And he focuses a part of his practice on appeals. So today we're going to be talking about what you do if the outcome of your divorce or family law case is not what you hoped it would be. So welcome, Jonathan.
Thank you.
So if you are in that situation, you've just been handed your divorce case outcome, and you're thinking it's unfair, and you're upset about it, what can you do?
Well, you would be entitled to appeal, and you can only appeal from final decisions. So if you went to court for permanent child support, permanent child custody, equitable distribution, which is the division of your assets, you could appeal from any of those decisions.
So how and when would you file an appeal?
Well, you have to wait until the decision is put in writing. So that means signed by the judge and file stamped by the clerk of court. And then you have 30 days from that point to file notice of appeal. And you would file written notice of appeal and with the same court that gave you the decision.
So while that appeal is pending, would you have to obey the original divorce order?
In most family law instances, yes. For most family law claims, the underlying order is going to stay in effect while the appeal is pending. You would have to ask the court to issue a stay, pausing enforcement of the order while the appeal is pending.
Okay, so let's talk about what your odds are of winning an appeal.
Well, for family law cases, most of the time the standard is going to be abuse of discretion. So on appeal, you're going to have to prove that the judge abused his or her discretion in making the ruling. And that means that the ruling is not supported by any of the evidence. And the appellate court isn't going to reweigh the evidence. So if you had a custody trial, for example, and you had 10 witnesses, and 9 said that dad should have primary custody, but 1 witness said mom should have primary custody. On appeal, that decision is likely going to stand because even though 9 said dad and 1 said mom, if the judge issued an order saying mom should have custody, it's going to be supported by evidence in the record.
Okay, so while that appeal is pending, is there a way to get the original order changed?
No. So after you file notice of appeal, it takes jurisdiction from the lower court that issued the order and gives it to the Court of Appeals. So you can't do anything in the lower court to change the order.
So this sounds quite serious. Are there any other options available?
There are a few things you could file with the court who issued the decision, asking them to either give you a new trial or to set aside their order. But those mechanisms only apply in very specific situations. You would have to be able to show some newly discovered evidence that wasn't available at trial, or maybe somebody engaged in fraud. But outside of those narrow issues, most likely if you're asking for a court to review the order, you're going to be filing an appeal and taking it to a higher court.
Okay, so if you're wondering if this is a possibility for you, what should you do?
If you're considering appealing, you need to, I would suggest, meeting with a domestic or family law attorney that handles appeals often, go through the facts of your case and come up with a plan.
Okay, excellent. Thank you, Jonathan.
You're welcome.
So if you would like some more information about this topic, you can contact Jonathan at the contact information included at the end of this video. Meanwhile, please feel free to comment and share. Thank you.